Hello, thanks for staying with us on BERNAMA today. Still with me, Leonora, and in the studio I'm speaking to Geetha Kandiah. She's of course the Director of Trademarks and Designs Division for CAS International. And earlier we were telling you about intellectual property, and specifically today we're speaking about apps and the question of, are apps patentable? How are you doing, Geetha?
I'm good, Elaine.
Glad to have you back in the studio.
Nice to be back as well.
And we're just giving a backgrounder in terms of when we were talking prior to the show coming on. Why specifically are we talking about apps today? And my main question was, is it because there's more influx of demand for apps to be patented and copyrighted?
It's relevant today because more and more technology that's being created involve apps in some way.
That's right.
People want to be connected easily and speedily, and that's through the mobile phone, through smartphones, through tablets. And the way you connect any device to a phone and tablet is through an app.
Essentially, everything that we do today actually revolves around an app, whether you're using Facebook, whether you're using Waze, and
Instagram.
Yes.
So social media, and then you have all the GPS apps, calculators, everything that you have that uses software on a device is an app. So everything that's created today, almost everything that's created today, connects the user to the invention through an app.
That's right.
So you get that question more often than not. Are apps protectable through patents?
Correct.
And patents comes up as a grey area for apps, and the reason being is apps is a type of software.
Okay.
And softwares can be protected through two ways.
Okay.
So earlier in our previous episode, we talked about intellectual property right as a whole.
Yes.
And it involves a few types of rights.
Right.
So you have copyright, trademarks, patents, and so on. With apps, you have two types of rights that it can be protected under, which is copyright and patents.
Right.
And the reason it can be protected under two is apps is through coding. So you've got programming language.
Right.
And programming language is considered a literary work.
Okay.
So literary work is protected by copyright. Copyright protects literary work, artistic work.
What do you call the expression of
an idea?
Right.
Correct.
Okay.
So that's been expressed into written work, and that coding is considered written work. And this again, Elaine, is similar. It's interesting because our law always catches up with the evolution of business.
Okay.
So technology develops and new things are created, and then our law tries to catch up with it.
Right.
So
as with a lot of things, you know, it has to evolve with the time.
And that's why acts are always amended.
Right.
And with the same thing here, it's software programming language is considered literary work, but it's very different from other literary work.
Right.
It's different from slides, it's different from articles.
It's like a mathematical equation of sorts.
Which delivers a result at the end of it. There's a
Right.
function at the end of it.
Right.
Can you imagine calling Waze and literary work?
It's quite peculiar. Yes.
So in that sense, it's so copyright protects the programming code, the source code.
All right.
And if there's someone who copies the source codes, they'll be considered infringing
on the rights.
Yeah,
correct.
So so it can be protected by copyright, but it's better if it's protected by patents.
Okay.
So patents protects the function the app delivers.
Okay, but I think this is a little bit of a not say conundrum, but it's quite hard to sort of figure out which in terms of the patenting, because I can understand copyright and source code. That's quite clear because it's like it's like literary work. So if you are copying, you will see what the source code is, and if somebody has that similarly, then you're infringing.
Yeah.
But for patent, how do you describe that structure that you are patenting?
All right, so patent itself, it protects products and processes.
Right.
And software falls as a process.
Right.
And there's three criteria that you need to protect a patent. It has to be new, it has to be inventive, and it has to be industrially applicable.
Okay.
And in history, before apps were created, patents were really related to technical products.
Okay.
So you're looking at machineries.
Yes, correct.
Razor blades,
Right.
mostly physical things.
Yes.
And then software comes along and it's tangible.
Yeah.
You can't actually hold it apart from holding the device.
That's right. It's not like this phone, and then you can't copy this.
Yeah.
But this is something that is out in space.
Correct.
Right.
So it's literally in the cloud, right?
Yeah.
But so then it gets quite like you said, peculiar. So what we have then tried to see is that whether this app solves a technical function or delivers a technical result.
Perhaps best illustrated if we have an example.
Yes.
Okay.
So let's take, for example, a simple app like the calculator.
Okay.
Or something to tell you what the weather is in a specific country that you go to. the calculator crunches numbers and delivers the answer.
Correct.
And it's just a mathematical formula being used.
Yes.
And the weather as well is just giving you information. So
Right.
it's data delivery.
Right.
And here's delivery of numbers that are calculated.
Right.
Those are mere simple apps, like simple processes that cannot be protected by patents.
I see.
And the reason is because that they're not considered to be complex. They're not considered to be more than not considered to be inventive enough. So whereas you have Waze, for another example, and Waze is, yes, delivery of data and crunching of numbers, tells you estimated time of arrival, and so on. So it's a matter of how is the delivery of data meant to deliver information to the user.
Right.
So you and I, when you and I use Waze, it's a lot of data being delivered from the users, from traffic reports. So there's different sources of information delivering data, and then it gives you the end result of how long it takes you to get from place to A to B, and how many routes you can use, how long it takes in different routes, whether you need to pay toll. So you can see it's not just a mere delivery of data, not mere crunching of numbers. It optimizes various sources of information and then gives the end result to you. So there is a technical solution it's providing for a problem that's existing. So that can be patentable. So in terms of what apps can be patentable, it has to be a bit more complex than a mere delivery of data.
So, but it's not simply just the complexity of the job, but whether or not it solves a technical problem per se.
Yes.
Okay. So essentially, because I think the question is, everybody thinks that if I create an app, I should be able to patent all my apps. If I create something that's different or unique, I should be able to copyright or patent it. So it's not particularly the case as such.
Yeah, but having said that, it's very difficult to realize whether your own app can be patentable. So it's highly advisable to get advice from an expert in this field. There are cases in the US, for instance, there's this very famous case, Alice, and it was decided that abstract ideas cannot be patented. So softwares that just implement abstract ideas.
What is that?
Yeah, it means that things that you can do in pen and paper, but you just computerize it and created an app, cannot be patented.
I see. Okay.
So there you go. The example I gave was a calculator app. And there's a lot of apps out there that just deliver data. So that wouldn't be patentable.
So earlier you were mentioning like ways that can be patentable because it's solving a solution. And I think, is there another example, perhaps for those who are still unclear about what can and what cannot be patentable?
Another example would be Uber. Uber is also patentable. And having said that, it's patentable in some countries. So some countries allow software-related inventions to be patented, and other countries have more stricter requirements when it comes to software-related inventions. So Uber has been patented in the US, and it's they have various patents on their technology of getting a driver to you at such a speed, and also giving you estimation of cost, and giving you various routes as well. So again, there are various patents on that Uber owns, but it really depends on what technical solution it is. So sometimes, if you have a software and you feel that it's merely a mathematical function, it's just crunching of data, it might not be so it's better to get advice, because it can be drafted in a way where it sounds like a system that is providing a technical solution to the end user.
But what's, in terms of locally in Malaysia, what's the market like, or what's the maturity like in terms of, well, both from an app developer's point of view, are they aware of what they can, and is the law already up to speed in terms of what's available here?
So our law has not been amended, and there's no examination guidelines when it comes to software-related inventions in the IP office. But other countries, the more developed countries, UK, Australia, and the US have guidelines created, and Malaysia recognizes if the patent has been filed in that country and a corresponding patents filed in Malaysia, our IP office recognizes the granted patents there, and because they have guidelines, we can rely on those guidelines as well when we advise clients here.
So are there new ones that are being created right now? So if somebody has just come up,
a guideline?
No, not new guidelines. As in, those are what you mentioned. What you mentioned was what's available in, say, for example, UK and Australia, and those become like what precedents that you are able to use?
So not so much precedents, but so patents are jurisdictional.
Right.
You get protection country by country.
Right, okay.
When you file it in one country, let's say in the US.
So, like for example, Uber is patented in the US.
Yes.
Is it then applicable elsewhere?
No, so your protection just is in the US.
Okay.
You then have to file another patent in the country that you want to venture into.
So what does Uber Malaysia have to do in that sense? They have to then file here.
But usually the headquarters will control all the rights. So they would have filed it. If
Right.
they're interested in the Malaysian market, they would have filed it in Malaysia.
Right.
So when we talk about its corresponding patent has been granted here, because they have guidelines, and the fact that the corresponding patent, the exact patent has been filed here, the IP office here will also rely on the guidelines that's been implemented in those countries.
Right.
So in Malaysia, we use those guidelines to guide us in terms of whether the patent will actually proceed to registration, to grant.
Right.
But with apps, it's another question is, should you even go for patent rights?
Yes, which is I think something that we want to talk about, because I think a lot of people are like, oh, okay, it sounds interesting that we have this, but what's the process like?
So patents in most countries take about 3 to 5 years.
Wow,
so it's not just Malaysia, it's the US as well, it's the UK. It just does take that long because it takes an examination process into consideration, and the IP office will have to examine the patent based on whether are there other inventions in this field that are similar to this.
So the question is it even worth the time?
If the app is in a fast-moving space where it's going to be obsolete in 3 years, then no.
Perhaps not. Right.
Because you cannot take an action against someone who's copying your patent
right now
if you haven't had it granted.
Right.
So you can apply for it today,
right?
And if someone's misusing it, you cannot actually sue them until it's been granted.
But post then you can.
Yes, and then you can do it retrospectively.
Right.
Damages can be obtained retrospectively. But so if it's not going to be in use in 3 years' time, you feel like that app will be obsolete and you'll be creating another app.
It'll be pointless.
It'll be pointless.
Okay.
Having said that, if you're improving, it's going to be obsolete, but you're improving on that, that's your base technology.
Yeah.
So if you're improving upon that, and Waze has been improved so many times with some more features, right? That should still be protected.
Right. Okay. Thank you so much for all that information. At the end of the day, if you have any questions with regards to whether or not you can copyright, you can patent, seek counsel, and you'll probably be able to get the best advice there. Yeah. There you go. Thanks for staying with us for this segment. We'll be taking a short breather right now. When we come back, we have more stories to share with you. Stay tuned.